Thanks everyone for coming. Welcome to our 2022 annual conference. This is the first in-person event since we've had our last conferences in 2019. And at that time, of course, we were focused on the implementation of the New York City Right to Counsel law. The tenant community at that time was working on the implementation, trying to get the word out to tenants in the designated zip codes of how important right to counsel was and how important it was not to default on your case, to come to court. You would get high quality, great legal representation for free. We were all just working on like getting the word out, getting folks to know about right to counsel. Everything was going very smoothly. The COVID pandemic then hit and turned evictions into possible death sentences. And the right to counsel for tenants took on a life-saving role. The city waived income and geographic qualifications, because at the time, of course, only people in certain zip codes were eligible. The court created pathways for tenants to be matched virtually to legal service providers and worked with the city to ensure that tenants got legal representation. Lawyers went to great lengths to reach people facing eviction and to help those with illegal lockouts, serious repair issues, and harassment. Everyone in this audience knows that on January 15th, the statewide moratorium expired and access to justice really splintered in the city and statewide. Our first in the nation right to counsel law fell apart as more and more tenants got court dates and for eviction and were going to court, and we were discovering that the court was calendaring the cases faster than the lawyers could handle them. What does it mean for a tenant to go forward without counsel? A number of us have been talking to reporters recently about like, well, why does this matter? What happens? What's it like? I can tell you from Housing Court Answers, we can tell you exactly what it's like to go to court without counsel because that's what we did for decades, right? Our work has been talking to tenants without counsel in housing court. Tenants get rushed into signing settlement agreements that they don't understand and that they don't really agree to. They agree to pay back rent that they don't owe. Rent stabilized tenants give up apartments that they have a right to, but are unaware of their rights, and so they agree to move out. Countless number of tenants live with really serious housing conditions that they shouldn't have to live with. Things like lead paint violations, lack of heat, lack of hot water. And untold thousands of tenants over the years defaulted on their cases, never showed up in housing court because they thought they couldn't win, they couldn't face it, so they just left. There are also thousands and thousands of tenants who came to our information tables with a marshal's notice, never having been to court before that point, 3 days away from when the marshal was supposed to come, trying to do an order to show cause to stop the marshal from putting them out on the street. And with counsel, we know that 86% of tenants with counsel stay in their homes and survive the eviction attempt. During the pandemic, tenants who called our hotline, virtually every single one of them with a housing court case, got legal representation. If they had an eviction case, if they had a serious harassment or repairs case, if they had an illegal lockout or a post-evict. I mean like everybody. There were no tenants who, unless they were doing it voluntarily, went to court without an attorney. And we'd like to return to that. We'd like to return to the time when tenants who need attorneys because they're facing eviction, because they have terrible housing conditions, because they've been illegally locked out. We want to return to a time when all of those tenants can get attorneys. And so our panel today is going to address those issues. I'm going to let Adriene Holder introduce the panel, but I just want to say thanks to all of you for coming. I want to thank our staff who are outside. If you can stay for the reception, I hope you will introduce yourselves to our staff who are out in the lounge or at the sign-in table here. These are the folks who've been answering the phones since March of 2020, really every single day that the phones have been open, Monday through Friday, through a really horrible pandemic, and talking to people with really frightening situations. I also want to thank John Jay College for hosting us. and giving us a huge break on the costs. It's a beautiful space, and we're happy to be back here in person. After this panel, we're going to present our Housing Justice Award to Assemblymember Linda Rosenthal, so I hope you'll stay for that. At that point, the chair of our board, Larry Wood, who many of you know, should be here by then, and he wants to give you all a rousing, introduction to the Housing Court staff, Housing Court Answers staff. So I'm going to hand the podium over now to Adriene Holder, and she's going to introduce her panel. Thank you.
Good afternoon. I hope everyone's doing well. Let me just tell you, it is a fine day in New York. It was supposed to be like torrential rains, and it's turned out to be really great. I want to first and foremost thank all of you, our community of housing advocates. If it wasn't for you and those who are viewing on live stream, as well as our esteemed panelists, we wouldn't even be where we are right now with Right to Counsel. And so I really just want to pause, because I say this all the time in certain circles that I'm in, but I don't know that you all hear it. I say this to folks that are upstate. I say this on the national listserv and Zoom meetings that I'm on as we're all trying to push this movement of Right to Counsel. But there is no better legal advocacy group than the group here in New York City. And we have wonderful organizers and attorneys and advocates, and I just really want to thank you all. We have the courts as a partner and the city, and I just would like to actually have you all give yourselves a round of applause. So we have a wonderful panel to discuss Right to Counsel initiative here in New York City, and what I actually would like for each of them to do, and again, I'm Adriene Holder. I'm sorry, I didn't introduce myself. I'm the chief attorney of the civil practice of the Legal Aid Society, and I'm also on the executive board for Housing Court Answers, so Jenny Laurie is my boss. And so I would actually like for everyone on this panel to introduce themselves and tell you who they are and what their role has been in this wonderful thing that we call the Right to Counsel initiative here in New York City.
Good afternoon, everybody. My name is Yeraldi Perez. I use she, her pronouns. I'm one of the deputy directors at CASA, Community Action for Safe Apartments. We organize tenants in the Southwest Bronx. And I actually started working at CASA in 2015, a year after the Right to Counsel Coalition was started. And so my work has been really supporting the organization in the campaign and working with tenants in the community to push Right to Counsel to be one, and then the implementation process that we've been fighting for since then.
Hi, good afternoon, everyone. I'm Jack Stoller. I'm getting a little used to saying this. I'm the Citywide Supervising Judge of the Housing Court. This is my 9th day in that position, so I've solved everything already, good, just to let you know. I started out, it's funny seeing here, I see former colleagues here. I started out at Bronx Legal Services a long time ago with a former colleague of mine here. From there, I went to Legal Aid with Adriene as my colleague, and I had a little stint at the Corporation Counsel's office. I was appointed to the Housing Court bench in 2010. In the past 11 years, I've had 1 year in Bronx County, 8 years in Manhattan, and 2 years in Brooklyn, and 9 days ago, I got shifted back to Manhattan because of this new position. In that capacity, I've been in the trial part, I've been in the resolution part, and I've been in the HP part, which was really eye-opening. In addition to that, I serve with, among other people, again, Adriene Holder, on the Chief Judge's Permanent Commission on Access to Justice. And I was also on the Commission on the Future of Housing Court that Janet DeFiore set up, but looked into a lot of these issues and looking into integrating Right to Counsel into the procedures in Housing Court.
Thank you.
I don't know how to follow that one up, but hi everyone, I'm Hegde. I use she, her pronouns, and I'm an attorney at the Policy Council of our civil action practice of the Bronx Defenders. I've been with the Bronx Defenders since the early fall of 2019, so it was just, I would say half a year or so before the pandemic really changed the world, and I still have memories of what housing court was like enough to kind of have seen the shift, which I'll speak to today. As policy counsel, I work on an array of different housing policy issues that work very closely with the Right to Counsel Coalition that Yeraldi and other really passionate grassroots organizers and tenant leaders have really galvanized and shaped in the last so many years. And I just feel very fortunate to work in a holistic practice where we see housing as, of course, the human right that it is, but the way that it has been shaped and affected so staunchly by other legal system involvements that our clients across the South Bronx and other boroughs citywide have experienced in vastly devastating ways.
Good afternoon, everyone, and thank you, Housing Court Answers, like Adriene, for inviting me here. My name is Raniece Medley. I am the Civil Justice Coordinator, no longer interim, for the Office of Civil Justice, which leads the Right to Counsel implementation in New York City. We are housed at the Department of Social Services for New York City, so we are within the government structure of managing and leading the implementation. That is my role. I will jump into more as we progress.
So let's start. So that's great, and I appreciate everyone introducing themselves. What is the role of the Office of Civil Justice Coordinator with the Right to Counsel Initiative?
Sure. So the role of the coordinator, the Civil Justice Coordinator, is just as I indicated, is to lead the implementation, the city's implementation of the Right to Counsel law. So we all know, you all probably better than most, right? What that law protects, what it was to get here, right? And what it was to have this implemented. And so in my role, it's there to ensure the delivery of those services, to ensure that we have what is protected under that law is what is carried out, to ensure that we have the legal service providers and that they have the appropriate supports and that we have the partnership and stakeholder engagement to bring that and to carry that law forward.
Okay, thank you. And maybe starting off with Judge Stoller, could you tell us what the court's role is in the implementation of the Right to Counsel Initiative?
Well, the court has, and it's interesting because in explaining that, that's really, there's sort of like BP and AP before the pandemic, after the pandemic, because before the pandemic, the court set up a variety of different court parts, housing help parts, zip code parts, where I believe that the way they implemented Right to Counsel was they picked the zip codes where most of the people incoming into the shelter system had come from. So those were the zip codes that any summary proceedings that originated in those zip codes were directed to those parts. So the court set up those parts, and there were like offices that staffed those parts and represented interviewed tenants as they came in, and those parts took on a different variety of things. And then AP, after the pandemic, everything, I mean, it changed month to month, week to week, what the courts did. Certainly, it was easier than it is post-January 15th because the volume of cases was stayed in large part by hardship declarations and ERAP applications and various other stays. So there was a lot of working with the providers to assure that basically the maximum number of tenants got represented. In the post-January 15th regime, obviously there are issues that we can talk about further, but ideally what the court had been doing and had been wanting to do was to continue some kind of intake mechanism so that incoming tenants in summary proceedings could be connected with whatever provider was staffing whichever courthouse and whichever borough in that day.
Did you want to make a comment too? Sorry. No.
Yes, I'm happy to, thank you. For the legal provider angle, I think the way that we as a movement see courts is sort of an equalizer for balancing the playing field, right, between litigants who are tenants, litigants who are landlords, and seeing housing court not to be this eviction mill. Unfortunately, that's the status that it's sort of taken in the public eye and certainly in practice. But I think a very fundamental part of what the Right to Counsel law and the word right is in it purposefully, right? It's not a program. It's not just a bunch of services that are funded for the sake of deliverables. It means that every tenant who is eligible and deserves to be given an opportunity for fair and adequate representation in court deserves that. And the court system is the vehicle and enforcement mechanism for ensuring that that happens. And so for what I guess the angle that I know I had shared with Adriene yesterday that I see play out, or we see as providers play out so starkly in housing court, isn't just the actions that are initiated by landlords, right, for eviction filings, but the tenant-led harassment and HP repair cases that are almost not even seen in the spotlight because they're not treated maybe by the court system or by other sort of active players in that system as priorities, you know. And so I think that's another part of the right to counsel spirit that, although was not contemplated maybe within a funding number or some kind of pot of money, certainly does translate to what we think of when we think of housing justice and what the court is tasked to do, which is to provide equal, fair representation for all kinds of cases that pertain to someone's right to housing.
And just following up on that, so Jenny kind of outlined where we are right now, and there's a real problem in terms of in this final year 5 of implementation, that there still are tenants that are moving forward without counsel. Why in this final year of implementation and at this particular time, why do you think that there is the mismatch between the attorneys and the cases that are being calendared?
Yeah, absolutely. I'll speak again from the angle of the Bronx because I think it's used as an example of a more magnified version of what we've seen from the angle of housing courts and the destructive impact of eviction filings on tenants. There was always a very high volume of eviction cases that channeled their way through housing courts in the Bronx and Citywide. That wasn't something that just happened because of the pandemic. Of course, it was exacerbated. So when we're thinking of pace of cases, volume of filings, and the capacity of lawyers on the ground, and I won't even just say lawyers, but advocates, right? I mean, like Yeraldi is an example of an organizer and a community of advocates who may not be standing in court before a judge, but sometimes, you know, are just as crucial, if not more, to ensuring that there is a support system in place for a tenant who is at imminent risk of homelessness. And so those support services, we have social workers in our office, benefits advisors, right? I mean, there's a whole community of advocates. And I think when we talk about pace and volume and capacity, that sort of outnumbers the sheer volume of filings. What we've seen happen, I think, even more drastically after the expiration of the moratorium, was that the numbers in terms of retention, attrition, you know, attorneys just not being able to keep up with volumes of cases and feeling, I think, this urgency of wanting to do more for our clients, but unfortunately the system just doesn't give us enough time because cases are being, you know, pushed through channels where judges are settling them and maybe not giving opportunities for lawyers to really form rapport with their clients, right, and tenants who can be screened for eligibility purposes. And so that effect, when you're you know, magnifying that to such a scale, where legal providers are only so many, in a place like our office, the Bronx Defenders, to give you an example, we have about 40 civil advocates or civil, you know, attorneys, civil legal advocates, social workers, benefit specialists, team administrators, and of that 40, maybe about, you know, 25 or so are attorneys, and it's amazing to see how many of those have just come out of law school in the last year. So thinking through onboarding and training, the public education component to ensuring that there is you know, a robust operation of people who can implement and be well-versed with the laws that we're abiding to in housing court. It takes a village and it takes a lot of time. And I think that's where the mismatch has played out in a way that isn't even just something that is a numbers game. It's actually very deeply personal and can be, you know, something that goes well beyond what we can even measure in our own case numbers.
And with the mismatch of providers to, you know, with intake, with the number of unrepresented tenants, what's been the experience of the courts during this time?
So it's interesting, I don't know if anyone saw it, this morning in the New York Times, there was a story about your organization and legal services about the huge numbers of attrition, and it's not just on the civil side, it's on the criminal side. And I think it's, you know, they talk about the Great Resignation, I think that that's part of what's going on. And at the same time that happened, one of the things that happened with the legislature that I found a little bit surprising was they had a moratorium, not just on evictions, but on everything. Like I couldn't decide a motion, I couldn't have a trial. I had, all due respect to legal aid, a pending motion from legal aid to be relieved as counsel in the case. I told them, sorry, I can't do anything, there's a stay, you have to stay as a lawyer. So we went from being able to do nothing to being able to do everything. It like fell off a cliff. So I think there was a time from December of 2020 to January of 2022 when almost nothing could happen with cases, and then all of a sudden everything could happen with cases at the same time that I think you saw this phenomenon of really, I think, greater than average attrition that the article in the New York Times is talking about. Just to put things in perspective a little bit, though, I just want to share some data, and maybe I should be careful using the word data because I don't have the actual percentages in front of me, but one of the things that has been unexpected after the January 15th expiration of the moratorium is that both court filings and court appearances are substantially lower from February to May than they had been in the last comparable pre-pandemic period of February, May of 2019. I'm not sure why that is. One of the things I would speculate on has been right to counsel itself, I think, has discouraged cases that don't have merit from getting filed. Don't know the data on that, but that's a speculation. Another speculation is that June of 2019 is when the Housing Stability and the Tenant Protection Act passed, which took away a lot of the incentive for landlords to try to regain possession of their apartments. And another suspicion I have is that there's still, despite the expiration of the moratorium, a lot of stays that are going on, particularly ERAP stays. And not only are there stays for ERAP, but a lot of arrears are getting paid for ERAP. So for whatever reason it is, the number of filings is down. And I think that that's good news, and I think that to the extent that there is an attempt to make the, I'm trying to think of the struggling capacities of the providers meet up with the caseload in housing court, that, you know, that's at least some relief that we're getting in trying to make those two come together.
And right now, we're being told that there's over 2,000, maybe 2,500 cases that are proceeding without counsel in housing court, and we extrapolate that the vast majority of those folks might have been eligible for right to counsel and may have actually wanted to be paired with an attorney. So just in light of that, what then is likely to happen to those tenants that don't have lawyers? Yeraldi, do you want to?
Oh, I'm sorry, I thought you were asking me.
No, go ahead, Judge.
And I've talked a lot.
Judge Stoller, you should go because you just finished. You should continue. Go ahead. Thank you.
Okay.
I have to remember to call him Judge.
That's all right. Don't stand on ceremony. It has been very frustrating. I mean, I think, I certainly speak for myself, obviously, but I speak for almost all my colleagues. I vastly prefer, it's no comparison to have an attorney in front of me rather than a pro se party. To have a pro se party in front of me to do it right, if it's a stipulation, there's a new statute that is passed on that, I'm sure you know. To correctly allocate a stipulation with a pro se party really requires a lot of investment of energy. It really requires a lot of investment of time, more than we have with the size of the calendars that we have. To have a trial with a pro se party, and I've been in the trial part for going on 3 years now, I literally explain everything that goes on. Because you have to. So how's someone going to know what's going on if they don't know what a rebuttal case is, if they don't know what an objection is, if they don't know what it means for something to get into evidence, if they don't know what an MDR is? I mean, sometimes I look a little crosswise when I explain what an MDR is, but you know. But to have an attorney in front of me, I mean, just even setting aside the justice issue, which of course that's obvious, but it just makes the court so much better in so many ways. So it has been deeply frustrating to have litigants in front of me who are pro se, to refer them to the Office of Civil Justice and then be told, you know, no one's taking cases right now, we can't do it. So, I mean, what happens with those cases? To some extent, it's up to the discretion of the court. I mean, the court can certainly say, you know what, this is a particular case where it can't go forward without counsel. In this case, you know, I don't carry your objection, landlord, the case should get adjourned. Say, one end of the spectrum, you might have like a licensee holdover where there's a succession defense. For someone to do that pro se, and you know, and that's really important, maintaining a rent-regulated apartment. For someone to do that without a lawyer, you know, maybe satisfying discovery obligations, that's a really compelling case where the case should be adjourned or stayed until counsel can be obtained. Other cases present different scenarios. Sometimes, quite frankly, there's nothing we can do and we have to proceed without an attorney. And so that's, I think, led to a need to rejuvenate whatever previous trainings and other support we've had for judges in how to deal with pro se parties. Again, there's a new statute that just passed. There's an amendment of RPA PL 746, which imposes a lot of requirements on judges in terms of allocution of stipulations with pro se parties. We have set up a training on that next week, and one of the participants in the training is the Center for Court Innovation, which puts together really great presentations on things like procedural justice, which are very important to courts with, that are high volume, that have a lot of unrepresented parties. In addition to that, from 2018 to now, for every new judge that has come in, I've personally been involved with the training of the new judges and with training them on particularly how to deal with pro se parties. I come from, like I said at the beginning, a background of legal aid, legal services. I've had the experience of clients who've come to me and said, oh, I thought I signed the stipulation because I thought I had to. I didn't know that, you know, I didn't have to sign it or so forth. So that's really colored my perception in terms of how to proceed, and it's colored my perception in terms of the trainings that I've given to, I think the total of judges I've trained at this point is the most recent 17 appointed judges on that point, where we talk about not just allocution of stipulations, but also how to properly deal with unrepresented parties in a trial context.
Yeraldi, what happens to these tenants without? Thank you, Judge Stoller.
So Judge Stoller gave an amazing, detailed answer. I think for us it's very simple. Folks will be displaced, folks will be evicted, and that's the bottom line, right? We will see the impact of these evictions, of this displacement, not just for that singular tenant, for that singular family, for the communities that we work with. And it's a cyclical routine, right? So folks are displaced, or folks can't find an attorney. They'll come to organizations, grassroots organizations like CASA that work in the community. We are also overwhelmed. We're not attorneys, and we do the best that we can to provide some sort of education for them to be able to represent themselves in court. But the bottom line is that even if folks make it to court, for every person that makes it to court, every tenant that makes it to court, there's folks that are self-evicting, right? Because they're scared, because of the conditions, because they're being harassed. And so I think that if folks are denied this right, the ultimate answer is that they will be displaced and they will be evicted.
Yeah, I 100% echo what both Judge Stoller and Yeraldi shared. I think what the self-help eviction, or that process of even just constructively evicting yourself through, or being constructively evicted because repairs and conditions are so bad, is a trend that unfortunately is just not measurable right now, given the vast more cases that aren't even being filed under that category, because tenants could be, we have a popular demographic of tenants, of course, in the Bronx and in other under-resourced areas where if you are undocumented and you were scared to alert your landlord or a law enforcement agent or someone about the conditions of your apartment and what rights you may have that you might not be aware of, there could be implications that are naturally going to cause fear. An individual who has ACS, right, Child Protective Service, kind of as a threat because of issues that, again, stem from housing disrepair, naturally they're going to be sheltered and scared and fearful. And so I think there's a whole population of this sort of unsaid demographic that we see very, very much at risk of coming into housing court, if not being sort of the vast majority of those who do. And I think the trend that we've seen as legal providers in not being able to provide full representation to that population, when we've sort of arbitrarily deferred to like an advice-only basis, it's not the same as having a right to counsel. And I know I've had clients who I've literally had to write, pro se litigants who have had to write scripts to, essentially being like, this is what you should tell the judge if you're in front of, a judge for a harassment issue or something like that. And they will do it, but the result still is not, sadly, kind of what Judge Stoller said. It's not what it would have been had a lawyer been, rambling the same spiel, which I don't feel is right. Obviously, there's an element of empowerment there that I think can feel very watered down when a tenant is essentially saying the same thing that a lawyer is, but is, again, made to feel or turned away from the system in a really ruthless fashion. But I think that is another huge element and huge power of what the right to counsel, when it's fortified and when it's enforced, has the power to do, which is truly keep people housed and to keep it simple, but truly, as Yeraldi said, it's the right to remain.
Yeah, prior to the pandemic, we had really been making great strides, although we were only you know, representing folks in about 25 zip codes out of the 75 now that we have. It was the idea that we were working with organizers and folks that were getting the word out in the city, who was getting the word out in the community, that they're going to be lawyers in the court for you. And so again, as you said, for those people, come on in, for those people who are undocumented or people who were scared, the idea that they actually would have someone who would stand with them, who would speak with them, who they could, you know, that they knew was going to be confidential but was going to be their advocate, that was huge. And we, you know, we really had to educate our community, like, you want this, you want counsel. In the early days also, a lot of people turned it down thinking, oh, I can resolve this really quickly. I'm about to get my tax return. I can fix this. But, you know, it was the work of so many of our organizers and advocates that really did the outreach in the city that really educated folks to say, you know, you want to have an advocate, and as we continue to roll this out and get this out in the other parts of the city, you definitely know you have that protection. And now it's kind of like working backwards, right? And so people know that the providers are there, but they're now lacking the capacity, and we certainly don't want to lose any momentum that we had in the protection of those folks. Again, because for people to not go to court, to self-evict, you know, that's going to be the loss of yet another affordable housing unit.
If I may.
Yeah, sure.
This is where the Office of Civil Justice, and just part of what our role is, as I mentioned earlier, in terms of that partnership engagement and collaboration. With the city, much of that is us wanting to keep open lines of communication, to understand what the root causes are, and to think through how we may address them through policy, how we can supplement where the legal services may not be available. Because the way that the civil justice program is able to provide any legal services is through partnership with the established nonprofit legal service, you know, with these established legal service organizations, you know, that have been in the community, right, and that have been doing this work and are the experts in this work. And so if it reaches a space, and as we've heard all of the reasons that have brought us to this space where their resources are at a limit, and where they're faced with that, you know, how do we meet that, right? How do we meet these tenants? How do we make sure that we deliver and have a provision of service, have education, have counsel for them, have some advice, as has been mentioned here, if full rep is not available, and how do we bridge that gap? And, you know, there's work that is ongoing. One of the critical pieces for us at the city is our partnership and collaboration with the public engagement unit from the mayor's office. I have a colleague here from that unit that is definitely takes the lead on managing that outreach, as well as the mayor's office to protect tenants that was in that space. But the other part of it is that us being housed at DSS, DHS, HRA, is that we're also connected there, and that's particularly key when we're talking about, for instance, ERAP. We know that one of the big protections with ERAP was the ability to stay a case, the ability for a person to be protected from eviction by filing an application. Part of the outreach that the city is able to do is to identify those individuals who have open housing court cases and do outreach specifically to those individuals so that we can ensure, or at least take all efforts to ensure that we don't have folks that are self-evicting, that they understand what their rights are and that they stay in place and understand the power of that piece of paper. And if it doesn't come, you know, if it's not the right piece of paper and the right person bringing it to you, you need to stay home, right? You need to not be scared by the letter that slid under the door and that sort of thing. So that outreach, as you understand, is absolutely critical, and it's something that the city has been able to coordinate and organize. And, you know, it starts with a letter, it's a phone call, and it's a door knock. Even in the midst of COVID, they were knocking on doors where they weren't able to reach out to individuals directly in order to be able to make that connection. And then on the other side, we say, well, then, you know, what's critical, and one thing that is beneficial with our partnership in engaging and having that conversation is that then OCA, the courts, have given us that intake space for tenants to be able to connect with attorneys. And I want to highlight that. Judge Stoller has spoken to that, but my understanding, again, I've only been in my role brief time, and my housing court is not my background, definitely litigator, but not in that space. But my understanding is that before the formalized right to counsel program, even where providers were obviously standing in these spaces to connect with those most vulnerable tenants, they were catching them along the way in the resolution parts, right, and catching them on the calendar. That intake part is a critical piece of where the tenants are able to connect. And as Adriene mentioned, that we've been educating them and preparing them to understand that when they get to court, that's where they're going to connect with counsel. So of course, there's always a concern if a tenant is not going to have that expectation met when they're there, which is part of the reason why Office of Civil Justice is preparing in July to be there if in fact an attorney is not able to be, so that at least the tenant understands that the city is there and that there is some provision of service advice that is coming. But I say that too because what that also means, and what we know from those that are on the bench, is that the tenant is going to be connected to counsel. And I understand, we all know what the right to counsel law indicates, at or near the first appearance or as soon as practicable, and that is what we work toward, right? That is the goal that we work to deliver on. So we're keeping our eye there. We're connecting tenants who have not already applied to ERAP. We're reaching out to them. We're now going to be at court so we can catch them so that they can file those critical ERAP applications and stay their case. Things that we can do, again, so that as we work on our plans and we work through with our providers, with the courts, so that we can get to ways to bring everybody together, so that we can make sure we're delivering and that we're not seeing any walking back of those protections.
Thank you. So, other than the obvious about having more attorneys, having more people that can actually take the eligible full rep cases, do the right to counsel providers and organizers actually have the resources that are needed for full realization of right to counsel? And if not, what is needed?
I'll say organizing always needs resources. And so, we have the resources and been doing the work, very thoughtfully, intentionally, and I think we do an amazing job at what we do, but I think resources are always welcomed and needed for us to be able to do the work that we do in a way that really reaches as many folks as possible. The Right to Counsel Coalition has been fighting for Local Law 53, which would provide and actually implement the law that was passed last May to provide funding for tenant organizing. We're in the communities day in, day out. Folks know our offices, folks know where we're at, know where they can reach us. And so it's really essential for us to be able to continue to have those resources, not in the short term, but really in the long term and sustain that, right? We know evictions are not gonna stop, in the near future. And so we need those resources to be able to do that. And that's from staffing to the very essential work that folks sometimes don't think about. Like we, print dozens of flyers, hundreds of flyers to be able to do that outreach. So I think for us, the resources are always welcomed.
Yeah, I also think that in terms of shifting the narrative and bringing more public visibility to the work that civil defenders do, and when I say civil defender, again, I'm not limiting this just to attorneys, but those who are truly taking on this pursuit of justice, as we all like to say, for those who are indigent and marginalized and are not empowered enough by systems to do it themselves. And I think there's something to be said about when you have, as Adriene said, yes, like if we had more staff, sure, that would be like this ideal picture of being able to have like adequate representation here or there, but we wouldn't be in this position if, right, like evictions were happening at all. Like I think that's something very, very sort of almost like watered down from when we talk about housing and housing injustice and the function of courts and this like broader paradigm. But I think there is something about partnership, as Yeraldi said, about investing in partnership, investing in resources. But from a holistic standpoint, like not every organization has the capacity to do policy advocacy and direct services kind of in conjunction. And not every organization has that capacity to have other advocates substantiate and really partner with lawyers. I mean, I can really truly speak to the power of how even just one social worker in our practice has shaped and truly fortified the ways that our clients are able to have defenses raised that, quite honestly, from just a singular lawyer perspective would not have been possible, just based on training, skills, and the investment that they have from their own vantage point as social workers. So I think there is something really critical to be said about bringing visibility to issues that are just as real as those who are fighting it from the criminal legal system perspective, and oftentimes the intersectionality of civil and criminal is so overlooked and needs to be talked about more. with this work to gain more support and resources from funding, from, just sheer numbers of people who are coming out of law school and graduate schools wanting to do this work. I think there's also a gap in sort of that reality as well.
So how would you all describe the implementation of the Right to Counsel initiative so far? And has the Right to Counsel initiative changed housing court, the experience of litigants, the judges, and how the city addresses eviction prevention as well as housing preservation? Whoever wants to go first.
If I just may say a couple things. I've been reappointed twice so far. When a judge is up for reappointment, they ask, you have to go through panels at the Housing Court Advisory Council and the New York City Bar Association. And they ask for attorneys as references. Now, most judges in landlord-tenant court are going to list both sides on their application. But in order to make sure that you're not cherry-picking, the application also wants you to list your last 10 trials and the attorneys for the last 10 trials. In 1994, I'm dating myself, when I started out at Bronx Legal Services, being a tenant's attorney was like being an endangered species or something. It was like, oh my God, I spotted one, It was, and it's, so most of the time, if you're writing down in your application the last 10 trials, the attorneys in the last 10 trials, those panels are not calling pro se parties. They're only calling the attorneys. And if the only attorneys they're calling are landlord's attorneys, that's a different world than a world in which the last 10 trials you list on your reappointment application are attorneys on both sides. And they're calling both of those. And so that's one way in which right to counsel, I think, improves the court. A second way is I think that you've seen a lot more case law recently on a lot of fields of law that have not really had case law. For example, I apologize, I forgot your name. Sia Hegde. As Ms. Hegde said, talking about not just summary proceedings, but also HP cases, harassment cases, 7A cases. I feel, I was in the HP part in 2019, in the trial part in Brooklyn in 2020, 2021. Because of capacity, I end up seeing a lot of HP trials I would have seen. I saw a lot more 7A cases, a lot more harassment cases, and a lot more HP cases where we had counsel. And when you have cases with counsel, that not only obviously it benefits the clients of those attorneys, and I think that they were able to take those because those organizations might have otherwise had to pick up eviction cases that right to counsel providers were able to pick up. But that means that you get more law. With more counsel there is, the practice is elevated, more legal issues come up, the judges write more decisions that get published, and you have a firmer basis on which to go forward than before, where I feel like in the HP part it was a little more like the Wild Wild West, where, there really wasn't much law there. So there's a number of benefits. And look, I'm not looking to trivialize what's going on with anyone who doesn't have counsel, but I do think, just as Adriene said at the beginning, you have the right to congratulate yourselves, because what has happened is undoubtedly progress, and it has undoubtedly made things better in a lot of ways in court than it was before.
Anyone else?
Well, another role that I have as the Civil Justice Coordinator is to do just that, document the gains, right? Document what we've seen. I mean, we know that as of the end of last year, over 540,000 households had received legal services through through the Office of Civil Justice and through the programs. We know that we have seen eviction filings drop by 40%. And just as we've heard across this panel already, we know that that is due to not just, obviously, yes, the changes in the law, but also what people know and understand is going to be happening when they go, that this isn't just going to be a rubber stamp when you file that case, and that you're going to be able to make those moves. And, you can go on to www.nyc.gov/civiljustice, but look at those, and I say that and jokingly, but, there's a lot of work that goes into that to really want to understand what that significance is, where you go from 1% of a population of respondents showing up in court with no one standing by their side, and to bring those numbers up well into the double digits, where you can expect that 7 out of 10, 8 out of 10 times that person is going to have an attorney standing there with them. And so, I mean, it can't be, you can't diminish, right? And you can't minimize the impact of just even what that is, across the board, and how that also is a beacon to other spaces, where this right doesn't yet exist in the civil side as well. So, I think it's quite clear to be able to see where that shows up.
What about housing preservation as well?
Sure.
Because
and
you
it-
have a lot in your portfolio.
No, absolutely. I mean, one of the things that's key is that, I mentioned obviously, and we all know that this lives at DSS, HRA, DSS, and, a big piece and a big part of this program coming about and being housed here is because of the homelessness prevention aspect, right? And so, as Judge Stoller mentioned, part of that consideration of even determining which of those would be targeted zip codes, et cetera, is how that connected and tied into what we saw happening with shelter entries, right? So here we're talking about the opportunities and all of those things that you all have mentioned and that we know go along when there is an attorney there to litigate and protect these particular interests, is ensuring the appropriate rent level, right? Ensuring that this person is staying in a space at a level that is affordable, ensuring that these individuals are in place and not entering shelter, but again, also being able to have that better connection, or I hate to say better, let me not characterize it that way, but the bottom line is obviously when you have that connection directly to where those benefits and those determinations are made and the connections are there, it can facilitate the ability to make connections, to better support individuals, to identify and connect them to rental arrears and things of that nature. So for instance, just as I mentioned that the Office of Civil Justice would be returning in the spaces where we were, but also showing up in the courthouses where we were not before to support eligibility determinations for legal services, to direct folks to ERAP, but we'll also be there with partners from HRA who will be back on site to do the one-shot deal determinations and to do the eligibility determinations. And so these are all those critical pieces of homelessness prevention that work together, right? So that the folks can get the money for the rental arrears, but also, if it's appropriate, to be connected with that support that they need to be able to remain, to have the rental assistance to continue. And so, you can't pull just one thread to understand all that is encompassed, not just to say within the Office of Civil Justice, but as we've heard all along here, to understand how critical all of the different stakeholders are and the roles that we play to deliver.
So one last thing. When I think about your portfolio, I also think about the group advocacy, the affirmative housing cases that are brought, and preservation of housing. Again, the idea that people don't self-evict because of conditions, the harassment. I was just talking to one of my directors on the way in here. We ran into each other on the street. The harassment that people endure. Talk to us a little bit about that part of it, because even though, it's in your portfolio, the idea that you all, the city, funds, or the Office of Civil Justice funds providers to provide these affirmative work, the group cases to really deal with housing preservation of the housing stock, right?
No, absolutely. Thank you. Yes, and that is it. Our shorthand, right, is AHTP, anti-harassment and tenant protection. That's our affirmative litigation side. Just even thinking, what stands out in my mind is what I heard very much about when I came in, because I was coming in just as, folks, we all say, it's funny that we say post-pandemic, but, we're still in the pandemic. We can say post-moratorium, but we are not we're still kind of in the pandemic there. But I say that because, there were so many critical things that we really, accentuated and really emphasized as we understood that this moratorium was coming to an end, but just generally with an eye. One of those things was a big campaign about illegal lockouts, for instance. I mention that because that was something that was clearly being a route to our anti-harassment and tenant protection, but that also put us in spaces with our outreach to learn and understand other ways in which tenants and which individuals are in danger of losing their homes. I mean, one thing that I think we all understand, and that one of the reasons why illegal lockouts, for instance, was one of the things that was emphasized, is because it's understood that if the courts are closed and if there aren't the systems available in the courts for landlords to seek relief, we know that they will seek their own relief. And so to be able to be in those spaces, to now be able to connect to this space, to understand some of the other methods that landlords are taking to move, dissuade, constructively evict individuals, we have the ability to do that. So yes, we have in a total body of contracts, the anti-harassment tenant protection folks. Many of our legal service providers that do eviction defense work have arms of their organizations that do this work. But then we have a select number of organizations that only do affirmative litigation. They're building group cases, they're advising, and these referrals come in through all spaces. We've been able to respond And those are resources that have been called on, for instance, for some of the most, distressing news articles that we have read that are the results of, bad landlords, I will say, to say the least. But, that's what that space is for.
Right.
Yeah, and I really think that, I keep saying HP repairs and harassment, because that really is the category of cases in my experience. I think a lot of my colleagues can agree that you come into probably the most contact with your clients in terms of, hearing their narrative, hearing their story, and those are the same clients that are going to be at risk of eviction. It's like, it's just because they're in one sort of affirmative litigation scheme does not mean that they are excluded from the summary eviction process. And this is the reality in that, like, I am still litigating cases that were emergency HP repair filings from last summer that are just sort of pending. Like, they keep getting adjourned months and months down the road until there's a 30-minute slot in a HP repair part or an HP part in Bronx Housing Court. I'm at a level where, I just filed a contempt motion for a hearing that was, again, adjourned 3 months down the road for lead-based paint in an apartment where there's a 4-year-old child, right? I mean, you think of these stories, and it's like, what is the rationale in saying that those cases should not be, as much as there's an agency tasked to enforce these code violations, what really is the rationale in saying that those cases should be deprioritized or maybe not seen in the same, light as some of these others that, just because there might be a judgment of possession that's issued and right to be executed, right? There's a different timeline, but it's needless to say that I think if we're thinking of what fair representation means and adequate representation, we need to think about the linear kind of trajectory of all these cases and who they affect, because I think the consequences are far, far, far more devastating for those that have to be constructively evicted.
When you think about the founding of, like, how this, the establishment rather of housing court, and to deal with, housing maintenance code violations. Judge, is there, I always think about what the priorities in terms of how, the entire court system prioritize certain types of cases in certain courts, certain parts. Is there any response to how that actually has been going? And I know you're new in your particular citywide position, but that has been one that's been very discouraging for us.
Yeah, there is a response. You're asking kind of an administrative question of how to allocate resources and so forth.
Yes.
And if X number of cases are coming in and they're this type of case versus Y type of cases coming in, or they're that kind of case, you allocate the resources based upon the numbers coming in. Now, when I sat in the HP part of Manhattan, for example, in 2019, the number of cases that came in meant that for 2 days out of the week, I actually did not have an HP calendar because that was the number of cases that came in. So those cases were trial days. So I had non-HP trials. And eventually the HP trials bled into that, and it was catch as catch can. But things are different now. So for example, in Brooklyn, where I just left, we opened up a second HP part because that's what the numbers dictated. So the numbers that are coming in affect us, how we do things. For example, the HP part typically was a self-contained part where the same judge did the resolution as did the trials. But as HP filings have increased, and they have increased in harassment cases as well, those go to the HP part, then the trials have gotten sent out to the trial part. So it kind of depends on how the numbers flex and how they come and go, and the way that right to counsel features into that is, and I just want to say for a moment about the HP cases that one of the things that is different about an HP case is that HPD is a party to those cases. And I have to say, I'm very impressed with the HPD attorneys I've seen. I think that they take their mission very seriously, and they really do believe in code enforcement, and they are very zealous about enforcing that. Usually, I think when you have an attorney like that who's advocating for code enforcement, where counsel makes more of a difference, are cases where HPD does not allocate their scarce resources to, like harassments, and in particular 7A proceedings. Whatever frustrations you have with an HP action, you really want to get a landlord to sit up and take notice. A 7A proceeding is remarkably effective at that, because the landlords don't want their right to collect rent to be taken away from them. And HPD does do some 7A proceedings, but when I've seen tenants organizations, there's a provider, Communities Resist in Brooklyn, that does a lot of them. I think Urban Justice does them too. They're very effective, but again, you need attorneys to do that. So that's where right to counsel, I think, really makes more of a difference in getting those kinds of results.
So maybe start with you, Yeraldi. What is it that the tenant movement can do to really ensure a real just and robust final implementation of the Right to Counsel initiative?
I think continuing to do the work that we do, continuing to spread the word about right to counsel, to add to the answer of the earlier question, I think right to counsel really provides a safety net for folks to be able to organize, and the result of that is a lot what our allies see in court of more HP cases, more 7A cases, and more proactive cases where folks are actually organizing. When I started at CASA, and I would go into buildings, folks would say, oh, I took the landlord to court on my own, right? But then it was our work to really make sure that we built a community where folks felt supported by each other and took proactive action in enforcing their rights to services and repairs. And so I think the work that has to be done is the work that we've already been doing to make sure that it's implemented in a way that's actually right for folks, that people are aware that they have that right, and that they're actually using it. And we're connecting them to partners and to attorneys, right, that can actually do that work.
Yeah, I think partner is the key word here. I really applaud CASA and the other kind of community-based organizations in the Bronx that I know Bronx defenders and other legal providers in the Bronx would not possibly get to do as much community outreach without. And I think, I'm going to kind of re-highlight the public training and public education component of right to counsel when it came to implementation and kind of the outreach efforts, and local law 53 certainly is a big key player that we're trying to get extra funding to help support. But I think there is a big arm of just operational investment when it comes to tenants in the community being able to see that it's not just a lawyer who's maybe a pawn of the system who's part of their team, but it's really, like this broad community-based support of tenant advocates, other tenant leaders, training them, empowering themselves to sort of know their own rights, and without necessarily needing to know the legal jargon per se, but at least enough to be able to stand up and self-assert what they are afforded under our laws. So that's, I would say, the biggest piece of ensuring just representation beyond just the walls of housing court.
So the proposed New York State right to counsel bill has in it a requirement that cases be adjourned until an eligible tenant can actually be paired with counsel. Why can't something like that be done here in New York City?
You looking at me?
Same question.
So this is a complicated question. I'm limited in my ability to talk about it. I know that as Adriene is a part of a group of legal services providers that has started just yesterday, in fact, having meetings with judges who are above my pay grade in terms of working toward whatever it is, and that's the most that I can say at this point. I mean, we want to have a dialogue. We want to talk about what can happen. There's not much more I can say besides that. I'm sorry.
Anyone else?
Well, I have the same question. I think it's totally possible. Eviction stopped during the pandemic. The sky didn't fall. Landlords are still landlords. And so I think, the reality is that they should be adjourned, and tenants should be able to access that right. And and if the courts refuse to, I think the stability of communities across New York City will really suffer, and New York City will suffer as a whole.
Yeah, and it's not just about adjourning for the sake of kicking the can down the road. I think that can be a danger, it's the other side of the coin almost, when you're thinking of just pushing cases for the sake of giving more time. But it's also thinking really critically about community resources as they stand now in home base, HRA, just like their own staff retention and sort of like underutility of their own resources that has caused a lot of delays in voucher processing, right, and subsidies to be administered. And I mean, I just anecdotally this morning was talking to a colleague of mine who said that the next home-based appointment they could get for a client isn't until November. It's like, what is the, you know, how is that going to be supportive if you're just adjourning for like a couple of weeks or like maybe a month, right? So I think just really thinking about, like, when you're thinking of an adjournment, it's not just about finding the next court date on the calendar, but practically, like, what support calls for that. And I think, like, feasibly and sustainably, like, how can legal providers be positioned to utilize the resources that are already pre-existing, but are also just as, you know, under-resourced.
And I guess as a footnote, we did start a meeting, and of course our civil justice coordinator is a part of that working group. I thought it was a very good first meeting yesterday. I just would like to share that I actually am encouraged, and with the partnership that the city OCJ is bringing in HRA, DSS into the courts, and the work that the city is going to be doing actually in the courts to provide eligibility screens, and with the court acting in partnership and actually supplying us, the court supplied us with some great data about the decreasing number of cases that are actually moving forward in the system. I'm actually cautiously optimistic that we could come to some type of agreement about how it is that we can change housing court in a way that still meets the needs of all the stakeholders. And perhaps there is going to be a better match and expectation as we move forward. I certainly think the conversations have started, and I think they're proceeding in good faith, and so I feel good about that. You know, where we actually land, we'll see, but I do appreciate the partnership that we've been able to have. So the right to counsel law is a model for several other cities and states, and we also know that, of course, there's this bill for New York State. Are there any lessons learned that any of you all would like to share with stakeholders that are trying to implement similar initiatives or right to counsel models?
I'm going to call the new card as well. It's not 8 days, but and I only say it because I'm coming into a space with, as I said, something that you all have been a part of in terms of bringing to fruition. So looking at what I would recommend or lessons learned is a bit early for me, just in terms of what I am in this space. I mean, one thing that I would recommend, and I think we've heard it from Jenny and obviously from Adriene, is to have that connection and the partnership, and to keep an eye on that, and for everyone to go forward in a space of believing and an understanding that everyone is committed at the end of the day to the tenant. And folks can lose sight and that sort of thing, but you have to go forward in an understanding and in a spirit of understanding that everybody is there for the same reason. And, you know, folks have different roles to play. They may have different perspectives about the issue, but when that's the mindset and that is what it is that's driving that work, that's critical to being able to advance, to be creative, to be innovative and collaborative. And I think that's critical in my time in the space. I know that's what allowed us to get here.
I think the perspective that I would add to that is very well put. Is it's not just about a system where we're trying to clear a backlog, right? These are human lives, and I think the issue, the sort of rhetoric, I mean, it shouldn't be rhetoric that we say housing is a human right, because it truly is an enshrined fundamental right. And I think when you, again, lose sight of that, it becomes very easy to see the system as just this, like, abstract institution that, right, is, like, easy to be abused and exploited and do all the things that are causing a vast amount of harm. But I think when I think of just the lessons learned over the last, I mean, I've only been practicing for like 3 years now, so I can't say from like the inception of when conversations started around this right in 2014. But it certainly worked as a device to empower and not disempower. And I think just being really mindful of the humanization component of what right to counsel signifies and what it really truly has the power to do, which is bridge community and alliances and certainly a partnership even with those of us in the community who are trying to create impact and a difference.
Yeraldi, lessons learned?
I want to just echo the collaboration, knowing the resources that are already in the communities that could be helpful in this implementation, and and that collaboration and open lines of communication.
So the last question is for the entire panel. And just from your vantage point, can you talk to us about what success looks like? Success with the right to counsel implementation, success with all that we've been trying to do with housing court. What does success look like?
I can start. I would say success is having housing court not be an eviction mill like it was and it's been. I would say shifting the culture and power dynamics that exist in housing court. You know, when I started at CASA, I would regularly go to a Bronx housing court, and I was confused as an organizer about what was happening, didn't know where to go, and really saw the power dynamics play out in real life. And so I think shifting that power dynamic, really making sure that folks have access to that right, and I think in an ideal world, making sure that there's no evictions.
So I mentioned earlier I was on the commission in the future of housing court that Judge DeFiore set up. You were on that commission also. Mm-hmm. That commission issued a report which talked about the assembly line aspect of housing court. And after the George Floyd murder in 2020, Judge DeFiore had commissioned a report by Jay Johnson about racial inequity in the court system. And he specifically talked, I feel a bit of pride of that because I was on the subcommittee of the Association of Housing Court Judges that submitted our report to Jay Johnson. And he talked about housing court, in addition to other what he called high volume courts, what he called cattle call culture. So what does success look like? It looks like not that. It looks like moving beyond that to, let me put it this way. I started out in housing court, and then I once had an occasion to bring an Article 78 proceeding, and I went to Supreme Court for the Article 78 proceeding. And what was shocking to me was every lawyer was there for every case. I was like, wow, imagine that. That shouldn't be like a crazy thing, you know? I think that there's an extent to which the maximal application of right to counsel solves a lot of those problems that are talked, not all of them. I mean, there's still other things that have to happen, no doubt. But right to counsel gets us so much progress in addressing the problems identified in both the Special Commission on the Future of Housing Court and Jay Johnson's report on racial inequity in the courts. And I think that ultimately success looks like a court where that's a court. There's evenly matched parties with counsel with full rights who present their cases, argue facts and law, and the court makes decisions based upon the merits and applying the law, not with, again, to use a line from the Jay Johnson report, the cattle call culture that goes on.
Yeah, I mean, housing, we all have heard, it's a racial justice issue, it's an economic justice issue, it's a gender justice issue, and I think really recognizing that it shouldn't stop and end at someone's entry into court, and I think the success looks like someone should not have to be in court at all, and people should not need to be rerouted to court. I think it's very easy to think that just because a case is discontinued, I'm just using the non-payment, run-of-the-mill non-payment eviction case as an example, that they're done. They don't have to ever see court again, and the reality is far from that, right? Where people are almost frequent flyers is a crude of a term to use for this context, but they keep coming back. And why do they come back? It's because poverty is, criminalized. It's made to be this horrible kind of manifestation of their circumstances that goes well beyond just saying, I'm just going to get a one-shot deal from HRA and pay and be done with this amount of arrears that's pending right now. And so I think success really looks like thinking of the system as multiple systems, as ways that people should not need to be in it to begin with. And I think that obviously it's a much larger, broader question than I think what we all can contemplate a solution for in the moment. But I think bringing the humanizing appeal to what this is doing to people on the ground, which is absolutely heartbreaking to see. It really has been horrible.
Success to me looks like delivering on the promise and to the letter of the right to counsel law.
So we can now open this up for questions. I don't know if people have questions. Oh, good, people do have questions. So I don't know, how long can we go? 5 minutes. Okay, so I saw a hand there, over there, and there. So you want to, however you want to do it.
So we know that, I don't think it's any secret to all of us that housing in New York City is an industry, and it's extremely profitable for those that are landlords. The rich get richer, while the poor get the picture. So my question to all of you, because we talk a lot about eviction prevention, but I want to see eviction elimination. And how do we exactly do that? What are your, I guess, responses on how we do that?
I would say organizing. You know, part of the reason why I think organizing is so effective, I think the legal course is great, but I do think it reaches its limit sometimes in housing court, and I think that in the organizing work that we do when we've seen major changes and shifts in power dynamics is really where folks have organized beyond housing court, right? And so I would say organizing, because nobody that has power gives up their power. So you have to take it.
Any other responses? Thank you. Next question over here. Yeah, you're on.
Hi, my name is John O'Tromke. I'm a bar applicant. I have actually a question about the right to counsel law. I'm not that familiar with it. I actually don't think I've read it, but I'm wondering if this law, it sounds like this law does not create any kind of impediment to an eviction actually being carried out, even if the tenant, the defendant, does not have counsel. So is it basically a right without a remedy, or if not, what is the remedy? Thank you.
I don't think that the word right is in the statute. What the statute does is it directs the city to promulgate a program to pay for counsel. That's what the statute does.
The terminology is access, that you would see access to representation.
I will say that I think the proposed right to counsel bill in Albany would go a lot further than the current statute that's in the city, is my understanding.
Yeah, I think that's right. And there's no private cause of it. You might have said that. I'm sorry. I was dealing with the microphone. But it's a very good question. Yes?
Hi, good day. I'm a borough assistant that works for Housing Court Answers. And I wanted to say first opinion and then lead it with a question. And I think my concern with the right to counsel is that I feel like the success or the vision of success is to have access to counsel for everybody who comes in. And there's a kind of a complacency that happened during the moratorium. Everybody was getting right to counsel, and it felt good. But we still, people who dealt with unrepresented litigants or people who are dealing with housing court issues on a daily basis, we're still seeing frustrations of repairs not being met, abatements not being discussed, cases not being fought for the tenant, and tenants wanting to give up the counsel because they would hear from the tenant that they wouldn't want to fight for them. And my question is success. We all get right to counsel. How does the RTC Commission commit itself to changing that power dynamics that was being discussed, where even if we all get right to counsels, how do we get that coddle culture not to be part of the right to counsel as well, where the attorneys are just saying, we'll take the cases where we think we can win. No, there's no grounds here. You don't need assistance. We're not going to support you. And it's not a universal solution. And yeah, how do we, once we get everybody an attorney, how do we change the dynamics of housing court for people to get repairs, for people not to commit to owing thousands of dollars that they shouldn't owe, when someone is charging them for 100% of the services and they're not getting 100% of the services?
I think I'll throw a pitch in for co-counseling and collaborating with colleagues on cases. So not just having one lawyer be assigned to a case, but really thinking holistically again of what support services can be instituted to ensure that it's not just about, right, like fighting a case for what it's brought into court to mean, because the enmeshed penalties that come out of even just someone's entry into housing court for an eviction process, like I said, 9 times out of 10, they're the same clients that come in for harassment and repair and often even illegal lockout cases, right? So that's, I think, a category that needs to be really highlighted. But you did bring up a really good point of just, when you think of actualizing the right to counsel and making sure that it has the operational infrastructure to do what it was purported to do, it shouldn't just stop at having an attorney be assigned, right? Like, we need to make sure that, like, we have reasonable time and reasonable access to resources in the community to make sure that we even comply with some of our own litigation strategies. It's not always in a client's best interest to settle a case. Sometimes going to trial, if they have a defense to assert, if that's in their best interest, we should be positioned to have the resources internally to fight for those. And on the flip side, it's not always in the client's best interest to go to trial. And I think just being really mindful of what those circumstances are on a case-by-case basis. Sometimes we just really need the time and to be able to investigate holistically.
Any other questions? Yes, I was wondering we were going to hear from the new executive director of Just Fix.
Welcome.
I think I know him.
Should I stand or?
Yes,
Okay,
please.
okay. Hi, everyone.
Hi.
So this is amazing. This is like all of my heroes in one place on one panel. And, I want to acknowledge Housing Court Answers, former board member, for putting this together. My question is, we talked a little bit about housing as a human right. And in some ways, you could say not being evicted is like 60% of that right, maybe 75. And the remainder is having quality housing. And the issue of, how do we make sure that tenants who need repairs or who are fighting harassment are able to get to court? And just a couple of ideas, and I'd love to hear your thoughts. One is, why not keep the HP part virtual, right? Most of the litigants are going to be filing pro se. They're going to have to appear numerous times. Why not do that? And related to that, and I know Ed worked on this a bunch, why not dispose of the notarization requirement, the filing fee requirement, just make processes like that more straightforward, more tenant-friendly, because otherwise the bottom's going to fall out on our human right to housing, right? We'll have lawyers for the evictions, but then people will self-evict, they'll be frustrated, they'll be harassed out of their homes, and we're not going to be able to keep up on the model that we have now. So just want to know your thoughts. And again, thank you for taking the time. This is an awesome panel.
So I just want to answer that real quick. Judge Schneider, who is my immediate predecessor, who technically is still on the payroll, getting rid of the notarization requirement is something that she's been working on, and she gave me a whole bunch of information about that, and so that's part of the agenda of things that I've inherited and that I'm working on, and I agree with that. With regard to the filing fee, I don't know how high up in the chain that goes. I mean, filing fees are very routinely waived in the commencement of HP actions, but just you want to dispense with them altogether, I don't necessarily have a problem with that. I've never heard that proposal before, but I think they're almost always waived anyway, so might as well just do the inevitable. With regard to virtual and in-person, I think contrary to popular perception, that's not an issue that cleanly cuts landlord and tenant. I've seen a lot of tenants who want to be there. I've seen a lot of landlords' attorneys who want to show up virtually. And I mean, the majority is the other way around, but there's advantages and disadvantages to both, and we're kind of stumbling our way around which means of appearing in court works best. There are real advantages and disadvantages to both, I have to say.
I think the directives around in-person versus virtual changed so quickly and unexpectedly, I think, at different parts of the pandemic. Maybe, Adrienne, you can speak to this, and Judge Stoller. It was like every court part was operating under almost its own directive, and so just because we had a directive on paper that OCA had administered, it was sort of like there were some judges that were like, okay, we're going to default, a litigant if they don't show up in person when it's supposed to be in person, and it would amount to literally what could be like a 5-minute appearance getting a rent ledger, right? I mean, it was like there wasn't consistency, and I think to your question, I think there's like a lot to be said about when we think of equalizing the playing field and being consistent and thoughtful and pragmatic. I think that's a very basic example of something that could maybe have an easier fix than just saying, let's just do whatever it is that each judge could kind of do arbitrarily when there's a wider directive.
I mean, the one thing I'll say is that it's easy to have, well, that's the problem, is an inflexible rule versus a case-by-case situation. Because you could have an inflexible rule that says we're doing everything virtual, or an inflexible rule that says we're doing everything in person. But what happens with the person with the ADA accommodation? Well, what happens with the pro se tenant who, or even represented tenant who doesn't have the technology to appear virtually? Who maybe could go to a kiosk or something, but then that adds like another level of whatever. So once you start carving out those exceptions, almost any one-size-fits-all regime that you've got, which in the spirit of consistency, which I understand, you want to know what your expectation is, but it's been very difficult. And I feel like following a lot of these directives, I 100% agree. They haven't been consistent. They've gone back and forth. It's been hard to figure out what's going on. And this is a process.
So I think we have time for one more question. Anyone? Oh, okay. Yeah, go ahead.
Hi, my name's Hannah Stanbaugh. I'm from DC 37. So we're not actually a right to counsel provider, but we're dealing with the same, deluge of cases and capacity problems and attrition and everything. And my question is, if someone could remind me what entity is, or group of entities is responsible for the rate that cases are being calendared? And I guess, I don't know if there's a direct answer to this, but why have they not slowed down the rate that the new cases are being calendared, at least until the COVID backlog clears? I'm having trouble seeing a justification for it, but.
Because the law requires it. Landlord files a case, we have to calendar it. That's what the law says.
Yeah, okay.
But what about after it gets calendared and then
Right, that's.
the further adjournment?
Well, what's the question?
So it gets calendared and perhaps, it's on. Maybe there's a screen, maybe there's, intake, but then that it is then put on a much farther out calendar.
So then that is setting a different policy, which is part of the conversation that we're having. But that policy has not been set, and that's part of a process, that's part of a conversation. Right now, case gets calendared because someone sues someone else, it's a summary proceeding, it gets calendared. That's what happens when someone sues someone else. It gets put on the court calendar when it's a special proceeding. In terms of what happens on the return date, there's individual judges who make their decisions about that. In terms of if there should be some kind of policy where, despite the statute saying what it's saying, the court should do something different, then that's a larger discussion, which is, coming into focus in a big way, and the reason for which the court system has opened up a dialogue with the providers.
Was there another question? Go ahead, sir.
If you don't mind.
Sure. And then we'll close out. I don't know if I'm handing this back over to Jenny or to Larry. Handing this back over to you or Larry? One more question. Okay, all right.
Hi. I've been with HCA for 22 years and never had a problem, but Social Security went up 5% in January. So HCA sent me a letter January 10th and said they were closing my case because I was $49 over the limit for my benefits. And I got the letter on the 23rd, and they said we're closing on the 25th of January. So I immediately asked for a trial, a fair hearing, I'm sorry. Now, I haven't heard anything back from them. This has been since January 25th. I did finally get a packet that was dated May 1st, but I wanted to go to the Amsterdam office. They won't let you come into the office. My caseworker has been gone for over 4 months. I have no caseworker. So I asked, can I come in and talk to somebody? They said, no, we're not letting anybody come in. You can fill out a form at the desk, and take it home and bring it back. That's all they tell me.
So you're at the right place. So between me and between, I'm sure some folks that might be here with our civil justice coordinator, we're going to make sure that you get some idea of how you can proceed. But overpayment cases are something that we definitely have a lot of experience in. My role is at the Legal Aid Society. So let's you and I talk outside after this, okay?
Thank you very much.
Okay, thank you. So I am going to, let me just say thank you again to our panel, and thank you all for accepting the very difficult conversation that we've had, but it was a good conversation. I really do applaud you all for volunteering and being a part of this. Raniece, you need to, Civil Justice Coordinator Medley, you need to get used to this because the Housing Court Answers always has our partner from the city, appear every year, and we hope that you will continue to be a force. And Judge Stoller, we're very, very happy to see you in your new role, and thank you so much for your work. And then, of course, our advocates and our organizers. I mean, Sia, Yeraldi, thank you so much for being a part. We miss Randy Dillard, who was supposed to be a part of this panel, who is so dynamic and would have infused this room with so much even additional energy that's here. So I thank all of you all, again, for being here, and those of you on live stream. We have more to do. I'm going to hand this over. I thought I saw Larry. Where's Larry? Oh, thank you. Yes. We're going to hand this over to Larry Wood, I thought. Okay, great. Hey, Larry.
Oh, boy. I'm going to take this off to breathe a little. Sorry I arrived late. I thought this was tomorrow. Jenny called me and said, you're supposed to kick this off at 2 o'clock. So, anyway, my name is Larry Wood. I work as a Director of Organizing and Advocacy at Goddard Riverside. I've been on staff there 34 years. And when I volunteered to be the temporary board president in 1993, I had no idea nearly 30 years later I'd still be here. But it's because of the board that I've worked with, an incredible staff and succession of executive directors over the years. I like to say I'm a useful figurehead. It's just been a great organization. We've had a lot of ups and downs, fiscally almost gone bankrupt when we got a lot of our funding line item vetoed by Governor Pataki, decades ago at this point. But we have made great achievements as well. And I really do want to do a shout out to the staff, because they've been frontline essential workers this whole time. And I know we did not close down for a second. Everybody went to staffing the hotline, which wasn't as bad during the pandemic. But once the courts reopened, we cannot keep up with the hundreds and hundreds of calls that come in every day from panicked, frightened tenants. And that's essential work and very difficult work, to refer people, to try to calm them down. And I know the emotional, spiritual toll the staff takes. It's been very difficult work. So I just really got to give them a lot of credit. And coming out of, we formed as a coalition, not a nonprofit. And coming out of 1985, we had written a report called 5-Minute Justice. And that was the average time a case was actually before a judge. Most of the time was spent, a landlord badgering a tenant out in the hallway to sign a stip. So out of that report, 5-Minute Justice, we called for a right to counsel. We called for clean hands legislation, which has to deal with code enforcement, which was just discussed. And we also called for plain language, which meant all the court forms should be in plain, accessible languages and not the legalese that people didn't understand. And I remember when we used to chant, what do we want? Lawyers? When do we want them now? People would laugh years ago. Now that cry is a lot more urgent, as you heard today. There's not enough attorneys out there. We've won a right to access attorneys, but now with not enough around, it's been very difficult. And honestly, I think it's a disgrace. The fact that the Office of Court Administration can't figure out how to slow down. Sure, the law requires that a case be calendared, but we got to slow this shit down. This is just unconscionable. So when I say OCA, you say shame. OCA? Shame. OCA? Shame. That's not loud enough. OCA? Shame. Thank you. So the tenant movement has won a lot of victories over the last number of years with the renewal of the rent laws, right to counsel, victories at the Rent Guidelines Board. Yet the crisis around the housing and homeless issues is worse than ever. The homeless sweeps, Goddard Riverside, we have the contract to do outreach to chronically street homeless people. It's a disgrace, the work, the sweeping of these encampments and our inability to maintain contact with and building relationships with people on the street to get them to accept services has really been interrupted. the tens of thousands of cases pending in housing court, the hardship, the numbers of people that are paying excessive amounts of money for their rent. It's just unconscionable where we're at. And it's not just a local problem, it's a statewide and a national problem. And we're gonna have to continue to work to build a movement to really see housing as a right. And I just also want to do a shout out to the Right to Counsel Coalition and Susanna and all of the staff there, and also pushing us to be more and more militant. Blockading evictions, putting people back into their homes post-eviction, civil disobedience, rent strikes. We have to up the ante as well as broaden the movement, because militancy alone isn't the answer. We also have to have a broad, united movement, which is always difficult to figure out how to work with your friends and your colleagues. So let me just end, and then I want to introduce my assembly member. I'm going to say housing is, and you're going to say a right. Housing is? All right. Housing is? All right. Housing is? All right. Thank you. Oh, I'm sorry. Let's thank the panel again. Yeraldi was an intern for us at Garden Riverside many years ago, and I'm glad we inspired her on a path to housing activism. One of my best interns. Okay, now on to the honors here. I can't tell you how proud and pleased I am to have Housing Court Answers present the Housing Justice Award to my Assembly member, Linda Rosenthal. I've really had the honor I've worked with Linda long before she even ran for the Assembly. She had worked for Congressman Nadler for many years and was a contact person there when Congressman Nadler would speak at God on an annual basis. And I remember when she decided to run and seeing her early on as a candidate, she was a little nervous. And it was really incredible to see her grow and blossom into the fierce advocate that she's become. And she's definitely one of the hardest and most dedicated Assembly members up there in Albany. A lot of folks up there, I don't know why they're there, but Linda knows why she's there. And she's there for a lot of causes beyond housing. And you have to give her credit for all the bills she passed and the passion she brings to the work. And she's got sharp elbows in getting work done up there, which is important. So, and her path to this really began when she almost got hoodwinked out of her rent-controlled apartment with, I think it was a grandmother who lived there. And not knowing the laws, the landlord was ready to kick her out and hoodwink her out with some harassment. But she learned her rights. She was able to prevail. That inspired her on a path to activism and getting involved with the political clubs and ultimately a path to public service. So I'm just so proud of my Assembly member and the work she does for the whole state. So I'm going to pass it over to Judith Goldner, who's the Vice President, and I think you're going to say a few words.
Thanks so much, Larry. I'm so excited that we're giving this award to Assemblymember Rosenthal because she's really been on the front lines for tenants, but not just on the front lines with us, making really important issues happen. You know, there are so many parts of our HSTPA that would not have happened without Linda fighting doggedly for them. And vacancy decontrol is probably the most important victory, I would say. Linda may differ with me, but that's what I think. But in addition, working with rent-controlled tenants who are really among the most vulnerable of the tenants in our city, they're disproportionately poor and they're very old, and making sure that their rent increases weren't the crazy increases that they had seen for so long. So I really want to applaud that. And most recently, when Linda got appointed to be chair of the Social Services Committee, working with her to get the increase in state FEPS up to the Section 8 levels. We've been fighting for that for so long, and it was so critically important. And all of that sounds easy, and none of it is. So I know that it took a lot of people organizing with her, but Linda is dogged, as Larry said. I always want her to carry bills that I care about because I know that she is gonna organize around them, and she is not gonna say, let no be the answer, and she is going to work it. And that's really what we need from our elected officials, and that's why we're so pleased to present Assemblymember Linda Rosenthal with this special award today.
We have to pose for a picture.
I'm happy to pose for a picture.
Who's taking a picture? A little awkward dance there.
There you go.
Thank you so much. This is really so very meaningful to me because housing is the most important thing in people's lives, really. And it's my honor to fight for people, for their right to shelter, for their right to stay in their homes, for their right to pay a reasonable rent, and for their right to live free of harassment. And that's why I get up every morning to help do that. Judith and Larry, we've worked together for years. Ellen is there as well, Ellen Davidson. And we're often huddling in my office trying to figure out our next steps. But that's also part of the fun. And I know we're weird, we think fighting is fun, but it is because we're fighting for the right thing. And so, you know, I've been in office since 2006, and as they alluded to, when I came home from college, I moved in with my grandmother in her rent-controlled apartment, and as soon as the landlord saw me, he's like, she is never leaving. And that's why, it's true, I'm still there many years later. But yeah, I didn't know the rules. I was very vulnerable, and through a series of, I guess, good fortune, it was a rent control, and the judge, who didn't know what he was doing, said I'm not immediate family. Of course a granddaughter is immediate family, but then he made me rent stabilized. I mean, he also raised the rent, but he made me rent stabilized, which before we fixed how much rent control tenants had to pay increases, 7.5, you know, I would have been up there, but now I'm rent stabilized, so it's still affordable. And so I wasn't evicted, but still in my building, it's the landlord's son. And he's trying some shenanigans, but I'm not going to let him do that. So over the years, I've worked with so many constituents who were at risk of losing their homes. Even today, it continues. Different circumstances, different reasons, but all greedy landlords is the real answer. I had a constituent. He was a wonderful man. He was 94. He lived in a rent-controlled building, 5th floor walk-up. And he did this every day. He went up, he went down, and the landlord was like, you know, I really want that apartment, so I'm going to harass the hell out of you. And I worked with some of our service providers here who went to court with him. But even after he won in court, they kept dragging him to court. And vacancy deregulation, once we passed that, put an end to some of that kind of harassment, because they knew that you may kick someone out, but the next tenant is still subject to RGB and you know, rules that allow them to get a new lease. Some of the things we've been fighting for in Albany around good cause, which we came very close to doing, but I know all of you are going to schlep to Albany again next year. To do that, and the HSTPA, Yes, landlords are still smarting from that. And yes, exactly. And you know, they decided that, I'm just looking for this, yeah. They decided once we passed that long fought bill, which, you know, fixed a lot of the problems that we were battling when the state Senate was run by Republicans. And we fixed it, and it was very dramatic. So a lot of the landlords are like, oh no, we're not renting out apartments. We can't recoup our investment. I'm like, first of all, you own a building in New York City. You're doing well. You're doing very well. And I don't want to hear their, you know, their comments. Last night was one of the RGB hearings, and I testified via Zoom. And today I see Jay Martin, executive director of CHIP, tweeted at me. 1, no one is warehousing apartments by choice. What does that mean? Warehousing means by choice. Number 1. Number 2, the law you passed makes it impossible to invest in below market units without losing even more money than keeping it vacant. You passed a law that promotes disinvestment. Own it. Owner talk. You know, I've gone to different apartments, once with Judith, and the place had a long-term tenant, maybe she was there 40 years, and he was saying he needed to pour $50,000 or more into upgrading it. What it really needed was paint, some new appliances, a nice cleanup, and it would have been fine for any of us to move into. But he was warehousing it. And this is the trouble, and I'm working on bills to address some of that. But, oh yeah, then Jay Martin said, the 100K came from where? Your imagination? How many warehoused apartments? I mean, we have a rough amount, but I'd say 100,000 is probably close to true. I'm not going to fight with him. We're just going to win in Albany. And, and you know, 421A, which is something that's it's a very troubling program. It goes out of existence, but there are many units that will be in it for years. And real estate was really liked that program. They love that program. But there are not enough rules, there's not enough supervision, and the city continues to lose out on billions of dollars of foregone money. Had the city and the state together taken that tax credit and built its own housing, we would have had plenty of housing right now, instead of like 2 apartments sandwiched in the back of the building within a separate door to go into, as it used to be in the past. So I also fought with all of you on Airbnb, and now they say how many apartments are Airbnb, not people living in, and we fought this, I don't know, years ago. We fought so many things together, and you know, that's why I want to stay in Albany. No one's running against me, so I'm not campaigning. But, you know, sometimes you think, why am I putting up with some of the nonsense that you get, like the hatred you get from people like Jay Martin and others? And it's because this job allows me to really, really help people. And it's corny, but it's true. You know, every day when I shut my door, lock it, and go to the office, I think how fortunate I am to have a rent-stabilized apartment on the Upper West Side. If I didn't have that, I'd be in Jersey, maybe. I don't drive, so I'm not sure where I'd be. But it's clear that, you know, people can't afford to live here anymore unless they're very wealthy. And that's not the city we want. That's not the city of the future. And so we're going to have to keep working together. And I know what great work all of you do. And I'm just so happy with this award. I might keep it by my bed. So thank you all so much for everything.
So, is any closing words, Jenny?
No, I was just going to say, invite people, there's food on the other side.
All right, food and refreshments. Thank you. Yes, thank you all for attending, and people out in virtual land, thank you for joining us. Sorry you can't enjoy the refreshments.